Professor Moreland, you mentioned the unique time we're in where the court's law regarding freedom of religion is very strong, and yet the culture is different than that, and the regard for freedom of religion is very weak. Do you think the latter, the culture, has either consciously or unconsciously led to the court being more willing to protect, considering its role protecting minorities?
It's a good question. It's hard to kind of read into the minds of judges and justices. I do think that with the expanse of the power of the state through regulatory means, and at the same time then the threats posed to religious institutions and persons with regard to free exercise of religion, I do think that maybe to some extent in the background that has led to a more acute appreciation than was, say, maybe true in 1990 when the Supreme Court decided Employment Division versus Smith, which those of you who've taken a constitutional law first amendment course know that's kind of ratcheted down from the prior regime, the levels of scrutiny to which burdens on free exercise are subject. And so to some extent, maybe in the background culture, there is this awareness that there are these threats to religious freedom. But I think that, as I said, I ended on a somewhat pessimistic note because I do worry somewhat for reasons that, for example, I commend you the Justice Alito's remarks at the Notre Dame Religious Liberty Summit in Rome a couple summers ago, in which he made remarks about this issue as well, about the ways in which the appreciation for religious freedom depends upon a culture in which religion is valued and respected. And you only have to look at the Pew data, for example, with the foundation, not pews to sit in, but the Pew data, the Pew data about the rise of basically the rapid disaffiliation from religion and what kinds of cultural effects that will then have on the law with regard to religious freedom, I think is a very vexed and problematic question.
Professor Moreland makes this really good point, right? The more the government expands, the more likely it is to come into contact or collision with religion or other people protecting other types of freedoms, right? So traditionally, and for a long time, like even prior to the New Deal, government regulated insurance companies because insurance companies are very prone to become Ponzi schemes. They take money from policyholders, they hold it for a long time, and then they return it. So you want to regulate insurance companies for reasons similar to regulating commercial banks, okay? It's quite another step to regulate insurance companies by telling them, if you sell an insurance policy, then you have to include certain coverages in it, right? One is a purely financial regulation. If you sell an insurance policy, we want to make sure you have the money to pay out to cover whatever it is it covers. It's quite another step to say, if you sell a health insurance policy, it's got to cover artificial birth control, right? It's when the government goes that further step that you end up with Little Sisters of the Poor.
Right. Actually, at Williams and Connolly, I was on a cert petition that was not granted on a case coming out of California involving a contraceptive mandate that was applied to employers. So this is a kind of forerunner to the Affordable Care Act's mandate. But it was striking that in the 1960s, the question was whether or not the state could prohibit the purchase of contraception. By 30 or 40 years later, the question was, could the state require religious institutions to pay for contraception to which they had moral objection? And that's the kind of rapidly changing culture in which I think these questions are being litigated and discussed.